The very same day that the disgraced ex-president was supposed to go on trial in a federal courthouse for his efforts to end democracy as we know it, that little January 6th insurrection, the highest court in the land today kept him on the ballot in a ruling that dodges the facts of January 6th and Trump's role in it. But instead, the Supreme Court handed Trump a second gift in as many weeks on a constitutional technicality. In an unsigned opinion, the justices say that states do not have the power to bar candidates from running for federal office. They say this, quote, because the Constitution makes Congress rather than the states responsible for enforcing Section 3 against federal office holders and candidates, we reverse. They're referring to the decision by the Colorado State Supreme Court. Now, that court found that Trump did engage in insurrection by trying to overturn the will of the voters by any means possible, including violence, and that Section 3 of the 14th Amendment does, in fact, apply to the presidency. Now, the Supreme Court's decision today does not touch on either the question of whether Trump is or is not an insurrectionist or whether the text of Section 3 applies to him. Instead, it says that only Congress has the power to do anything or to enforce the 14th Amendment. And as Colorado Secretary of State Janet Griswold points out in her reaction to today's ruling, quote, if we had a functioning Congress, we would not be in the situation we're in today with American democracy. In a separate opinion, the three liberal justices blasted the majority on the Supreme Court for closing the door on the possibility of federal courts disqualifying Trump or any other candidate who would engage in an insurrection. Writing this, quote, Section 3 serves an important, though rarely needed, role in our democracy. The American people have the power to vote for and elect candidates for national office, and that is a great and a glorious thing. The men who drafted and ratified the 14th Amendment, however, had witnessed an insurrection and rebellion to defend slavery. They wanted to ensure that those who had participated in the insurrection and in possible future insurrections could not return to prominent roles. Today, the majority goes beyond the necessities of this case to limit how Section 3 can bar an oath-breaking insurrectionist from becoming the president. Although we agree that Colorado cannot enforce Section 3, we protest the majority's effort to use this case to define the limits of federal enforcement of that provision. That's where we start today with some of our most favorite experts and friends. Former lead investigator for the January 6th Select Committee, Tim Heaphy's back with us. He testified in the Colorado case when it was in front of the state's court. Senior editor for Slate and host of the Amicus podcast, Dahlia Lithwick, is back with us. With me at the table, once again, former top official at the Department of Justice and MSNBC legal analyst Andrew Weissmann's here. And Princeton University professor and distinguished political scholar Eddie Glaude is at the table. So nice to see you, my friends. Let me start with the what of it. Andrew Weissmann, with you. What did the Supreme Court say and do today?
So they did a lot more than we thought they would do. Everyone after the oral argument thought that Trump would be allowed to be on the ballot in Colorado and, frankly, any of the other states. And
just explain why we knew that, why we thought that.
Because the argument, a lot of times people say you really can't tell from an argument. Here, there was just no friendly question, and you had no friendly question. You had a legitimate argument. And you had sort of the atmospherics of the court being, we don't want to be the ones deciding this. The reason they went further, and the reason this is a 5-4 decision, is where it sort of went to. Everyone agreed he can be on the ballot in Colorado and that the states cannot decide this. The reason it's 5-4, and notably the men versus the women, which was just a remarkable split, with Amy Coney Barrett joining the three so-called liberal justices, was that they said this applies not just to the presidency, but all federal office holders. Technically, what was before them was just the president. But more than that, the big sort of 5-4 split was that the majority said only. It's not that the states can't do it. It's that only Congress can do it. So you're picking the one institution that is completely dysfunctional and isn't going to do it. So if you want the big picture, you want to read this provision out of the Constitution, the only way to do it is to say Congress has to enact legislation to implement Section 3. no room, as you pointed out, for the courts, the federal courts, to step in. That's the part where Amy Coney Barrett said, look, why do we need to reach that? You are sort of needlessly inflaming in a political year the issue when our job in the court should be to try to just decide this issue and lower the volume. Lowering the volume by not weighing in Tim Heaphy on whether he is or is not an insurrectionist?
Yeah, it doesn't touch the core facts, Nicole. The Supreme Court decides questions of law, not questions of fact. They, as Andrew just explained, found that Section 3 of the 14th Amendment cannot be invoked by a state government. It has to be invoked by Congress. Some of the justices went further and said it'll take actual enabling legislation. But what America should take away from this is that that's a question of law, not a question of fact. The Supreme Court didn't find that Colorado was wrong in its finding that the former president engaged in insurrection. They actually found that he did. Several states have similarly found, much as our committee recommended. And those are the allegations, the factual allegations, that are going to come before federal juries, barring Supreme Court ruling on an immunity question down the road. So it's a victory for the president because it keeps him on the ballot. But again, it just doesn't touch really the core issue here was whether or not what he did on and before January 6th was criminal. We found that it was. Special counsel has alleged that it is. And ideally, a jury will get to decide that question in some months.
Ideally. Dahlia, let me show you what Judge Lithwick said on this show. We're down in the weeds, but I think our viewers have alongside me. We've all earned our honorary law degrees, right, over the last 6 years. So it's a little technical. Consider yourself warned. But here's Judge Lithwick offering a different legal analysis.
It is not necessary in order for the former president to be disqualified or for any other person who comes within the ambit of Section 3 to be disqualified, that he or she have been convicted of an insurrection or rebellion, nor is it necessary that the Congress of the United States have found that the former president or any other person have engaged in insurrection or rebellion against the Constitution of the United States. That's what we call in constitutional law the self-executing character, if you will, of Section 3. It does not require a congressional finding, and it does not require criminal conviction.
I guess what's so amazing, I've been back in the chair 6 days, and this is the second day where another body is I guess it's the same body, doesn't want to deal with the whole insurrection thing, doesn't want to deal with the extraordinary nature of what Trump did. They're not allegations. Trump carried out an insurrection. By November, it'll be part of his convention video, right? I mean, it's who he is. He's running as an insurrectionist. He's running on pardoning his fellow insurrectionists. His insurrectionist accomplices in the Congress are ascendant. The people who weren't quite as into it are either gone, out of office, or retiring and resigning. And now you've got the Supreme Court living over on Earth, too, where maybe that didn't happen, and maybe not. The voters will get to see all the facts in this case against him.
It's such an interesting problem because on the one hand, you have the court performing what looks like some version of institutional humility, right? Who are we to decide whether an insurrection happened? Who are we to decide, these complicated questions? Congress has to decide. That looks like it's a kind of democracy expanding, democracy affirming move. And it's very much, I think, in line with we're umpires, we're balls and strikes people, we do as little as possible. I guess I would just note two things in response to that. One is, and this comes up in the concurrence that the three liberals offer, which is they literally name check Dobbs. They say all you needed to do was do what Chief Justice Roberts said we do in Dobbs, which is decide as little as possible. The court clearly did not do that today. They foreclosed a whole bunch of different avenues. But it's also, and this is where it's really sneaky, the court doesn't actually tell us what that enabling legislation would look like. So even if Congress could shake it off tomorrow, get it together, write some kind of meaningful legislation that could in fact knock an insurrectionist off the ballot, the court reserves to itself the power to tell us whether or not that's okay. So it is both the most braggy humility and the most sort of humble bragginess in the history of humility. It's such a strange posture for the court to want to stay out of it while yet again putting a thumb on the scale for Donald Trump.
Eddie.
I'm just thinking, I'm not a lawyer by any stretch of the imagination.
Say that every day.
And I'm failing the one else, right? But I keep thinking about the historical parallels.
Yeah.
I'm thinking about the Civil War amendments. I'm thinking about radical Reconstruction between 1863 and 1877, right? And I'm thinking about the context of the 14th Amendment in response to Andrew Johnson's refusal to hold the South accountable.
Right.
We have literally traitors who are running for office, who are taking hold of the reins of power in the South after leaving over 600,000 people on the battlefield dead. And people are like, no, we have to hold these folk accountable. And so the Civil War amendments emerge in a context. Section 3 emerges in the context to hold folk accountable. And here we have in this context, right, a hesitance, that's a reticence, a refusal to hold this man accountable and those folk who engaged in insurrection. It's a historical echo that screams with irony, for me at least.